Hello, everyone. Thank you for joining McGuireWoods for the second installment today in our What You Need to Know, Protection, Enforcement, and Defense of Trade Secrets webinar series. Today's installment is focused on enforcement of trade secrets. My name is Sabrina Beldner, and I'm serving as the moderator for today's panel. I'm a partner in the LA office of the firm. I chair our labor and employment group, and I'm one of the firm's leaders of its trade secret practice group. Today, I'm joined by three knowledgeable colleagues and panelists. The first is Wolf McGavran, who's a partner in the firm's Business and Securities Litigation Department in our Washington, D.C. office, who specializes in trade secret litigation. The second is Yasser Madriz. Yasser is one of our Houston-based partners in the firm's Business and Securities Litigation Department, and he's a co-founder of the firm's trade secret practice. His practice and is entirely devoted to complex bet-the-company trade secret litigation. The third panelist is Mike Phillips, who is a partner in our Chicago office. Mike is also a co-lead of the firm's trade secret practice group, and he routinely represents employers and sometimes their employees in trade secret disputes. Now, during this panel, you may see a box on the bottom left of your screen where you can submit questions. We are targeting to leave 5 to 10 minutes at the end to try to answer questions that have been submitted by attendees. So with that, I want to kick this off. And as we talk about trade secrets, there's a lot of different types of people that we need to consider when you're worried about protecting your trade secrets. Of course, for my world and the employment practices world, you have to consider employees, right? But you also need to consider your competitors. You need to consider vendors, contractors, and cybersecurity attackers. These are all people who could be after your trade secrets. So where does that leave us, okay? We're all familiar with that common fact pattern that occurs in trade secret cases, right? A group of, ABC companies, employees, all resign en masse to join a new competitive upstart, and they're all going to the same company. And by hiring them, the competitor effectively acquires an entire business unit of ABC company. Okay, we all get that phone call. It's one of you who are attending today calling. Your general counsel has told you you have to take immediate action, sue everyone. Okay, so in these cases, there's always a natural reaction to file suit. But is there any pre-suit advice that we would give to the company and to its general counsel in that situation? Yasser, why don't you kick us off here?
Sure, happy to do it. Thanks for attending, and happy to be here speaking on these subject matters that are very near and dear to us. Obviously, when you get that call, you got to be very careful, because the first thing that the GC wants to hear is we're gonna do what's necessary. And obviously, time is of the essence, but it's also very important to put your best foot forward in these type of cases. So it's highly important that you take certain steps before going forward with full force. So one of the things I first recommend is to gather your evidence. Gathering evidence as quickly as possible will help paint a clearer picture of the situation at hand. That is the what, where, when, and how, if you will. So who are the culprits, which will help you identify who should be targeted in whatever action is going to be crafted. When did the theft start? When was it effectuated? How was it effectuated? And what is the nature of the harm? For instance, is there threat of imminent and irreparable harm? Is the secret to the secret recipe of Coke in somebody else's hand? And once you have that information, then it will help you formulate the best legal strategy to move forward. The second thing I'd recommend is to help preserve evidence. It's so important to preserve evidence. It's not enough to collect it, to collect the evidence that helps you, but also to take steps to preserve the evidence that's going to be at issue in litigation, right? Because when litigation is initiated, the defendants are going to invariably ask for a certain amount of discovery that you may not have gathered because it's not necessarily directly on point or helps advance your case. And if you don't have that evidence, you inadvertently give the defendants the ability to actually counter with a spoliation claim. The third thing I'd advise is to evaluate your trade secrets. there is a growing trend across the United States where courts actually have that as a precondition. In order to proceed forward once you file a lawsuit with your trade secret case against defendants, certain cases, is still the minority of courts, require that a plaintiff identify the trade secrets that are at issue. So having those things, those trade secrets identified, is always very helpful because it impresses the court that a plaintiff has solid control about what the case is about. One of the things we always recommend is for companies with trade secrets to identify those trade secrets well in advance to them even having an issue where litigation might be necessary. And one of the cautionary notes that I always tell clients, and this is the last thing I usually advise, is I strongly advise that they instruct their remaining employees not to talk negatively about the departing employees, because again, the worst thing you want to do is you have a clean case against a set of employees of wrongdoers who have joined a competitor, and now you're going to engage in disparaging those people, right? And by doing so, what you do is you inadvertently arm them with a potential tortious interference claim against you. So 4 things to keep in mind.
Thank you for that, Yasser. Wolf, Michael, do you have anything to add?
Sure, I'll jump in. I think the identifying trade secret and evaluation of trade secret step that Yasser mentioned is underappreciated. At the beginning of a case, you might have quite limited information, and not everything that a company has is necessarily a trade secret, but that doesn't mean it's not protectable for some other reason. For example, in your hypothetical, most employees have some sort of confidentiality obligations. So even if something may not qualify as one type of protectable information, trade secrets, of course, have a long list of requirements that you have to meet. It could be protected some other way. And you want to go in early on in a case with a rifle shot and then go through discovery to find out the true extent of what was taken.
Yeah, and I'll add one thing to that, which is for those of you who are in-house counsel, involve your business people in that process of identifying trade secrets. I think invariably we get a zip file of documents that somebody took, and the ones that seem like they're really damaging and important, a business person, a sales manager, or someone else will say that's really not anything special. That's something everyone has. And by the same token, a document that looks fairly innocuous, will be the keys to the kingdom. So, it's really helpful to get the business folks involved early in this evaluation process and not wait for discovery to try to figure out what of this cache of documents that was misappropriated is really important.
Thanks for that. Now we heard Yasser mention gathering evidence and preserving evidence. Obviously, that's part of what the company needs to do to determine if trade secrets have been taken and if there's evidence that it has that it can use. So how do you determine that, Wolf?
Yeah, it's a great question. I mean, so trade secret, like a lot of types of wrongdoing, frankly, when a trade secret's misappropriated, nobody's spiking the ball saying, yeah, I've done it, I've misappropriated your trade secrets. It's something that, if successfully done, you'll never find out about at all, potentially. So as a company that's looking out for this issue, what can you do? And I think, it coincides with what Mike was saying, was listen to your business partners. If you're in the general counsel's office, what are your business counterparts hearing, and what are they hearing from customers and from their vendors? That's often the first sign that something is amiss with respect to trade secrets. Another way that you might initially notice or have some suspicion is if a competitor comes out of almost nowhere, able to offer services or products that previously they weren't able to do. When something happens overnight, seemingly out of thin air, that's sometimes a sign that something is amiss. And if you've had recently departing employees, for example, it might be worthy of extra scrutiny. Now, in many, many, many trade secret cases, and this is going to be a theme throughout this discussion, I suspect, forensics of computers is extremely important. And when an employee leaves, and especially if you have some of those red flags that I mentioned, companies should consider doing in-depth forensic looks on those machines or their phones or other devices. Work emails can be monitored. website addresses can be monitored. Of course, what devices have been plugged into a computer, USB devices, writable CDs, things like that, can all be determined from a computer. Phone logs can be reviewed. Unusual activity, shortly before employees' departures can be detected. So all of those are tools that can help determine if something went wrong. And a common fact pattern is a company has a suspicion that something is wrong. They go to their IT department or an outside vendor or law firm. The computer is examined, and sure enough, there's some suspicion of foul play. I'll toss it up because I'm sure other folks have things to say on this. I'll say, you do want to be careful as in-house counsel on this, because your ability to rifle through individuals' information is not unlimited. So you want to be sure to check your internal company policies and any applicable laws. You've got, of course, in the United States, things like the Harmful Access to Computer Acts and Stored Communication Acts at the federal level. So just be aware of that as well.
Yas or Mike, anything to add on that point?
Just one point on forensics. There's a lot of IT departments that have forensic tools or even fashion themselves as being forensic experts. And we do sometimes get clients who say, well, I sent, this to our IT department. They said there's nothing there. While they do have forensic tools, there are outside vendors that have much more robust forensic tools. So if it's really something serious, I would, really strongly recommend retaining an outside vendor, not relying on in-house IT. And the other factor too is that once you have your IT department start doing searches, you make them witnesses, and you need to think about that as well. Do you want them to be witnesses? Are they going to be strong witnesses? Whereas an outside vendor usually has experience testifying, or have people that have experience testifying that will, sometimes make better witnesses than your in-house folks. So that's just one thing to keep in mind on the forensic piece of it.
Yeah, Mike, I think you bring up a great point. That's the first thing I always tell clients is just keep the chain of custody of that computer clean and don't touch it internally, because that person who looks at it internally, they could leave your organization. They could be, they could basically be annihilated as a witness who's interested because they're still employed. Whereas that sort of third-party expert may carry more clout right from the get-go, and you don't want to muck up the chain of custody. Yasser, anything before we move on to the next topic?
Sure. I think you're, for the audience, they're going to start seeing how well we work together, because I thought the same thing. That's the most important thing a piece of advice I could ever give. And Mike took it right, the thought out of my mind. But it doesn't matter how good of an IT department you have. Make sure that you hire the experts, because your IT department, no matter how good they are, they don't specialize day in and day out and exclusively devote themselves to just forensic work, right? It's so important. Most companies are not going to have at their disposal the cutting edge software that most forensic vendors utilize. And I routinely see the difference between the work product that's created by an in-house IT department and that from an expert, and it's night and day. The things that they can extrapolate from the forensic artifacts that remain in computers and phones, even from the server itself, is just night and day. The other thing, I do think, though, you get the best result when you put them together, because the internal IT department identifies the software capabilities of the company to the expert, and the expert can then go ahead and once they're empowered with that information, they can maximize the total information that can be pulled from the software that the company is using to safeguard their trade secrets.
Got it. So now we've done our investigation and we've caught Johnny red-handed. We found some information against him, and we think we're ready to move on. So what step do we take next? How do we decide whether it's time to file suit or time to do something else first? Mike, what are your thoughts here?
Yeah, my bias, if we have evidence, if we think we have good evidence, is always to file a complaint. And that doesn't mean that you can't try to resolve a case at an early stage. But I think filing a complaint does a few things. One, it sends a message to the other side that you're serious about this. It communicates a sense of urgency, and I think it's sometimes a little bit hard to go down a path of trying to resolve something, send cease and desist letters, go back and forth for a month, then go to a judge and say, "Oh, this is an urgent matter where we need expedited discovery or injunctive relief, or what have you." Right? There's a little bit of inconsistency between the delay and then trying to send that message to a court. And the other thing is, I just don't like giving the other side or the employee involved a chance to cover their tracks. And even though we know as lawyers that the duty to preserve evidence arises whenever you first have a whiff of litigation, I think that the complaint makes that preservation obligation a lot more real and tangible to the other side. And we do obviously see people trying to cover up and get rid of documents or do other things once they know that they've been caught. So I think all those things are important. And if you really want to try to resolve this without litigation, file your complaint and send it to the other side and say, "Here's the complaint we filed. We'd like to talk to you about this. Please give us a call, within 24 hours or 48 hours or something that communicates the urgency of it." But you can take that approach and kind of use it as a launching point for discussions. But I always like to, get something on file if I think I have the evidence to support it.
Yeah. Now, Yasser, Wolf, what if you have a client who doesn't want to put a complaint out there into the universe just yet, but yet they still have this evidence of trade secret, misuse? How and what would you guide them to do?
I can jump in. There could be instances where your evidence isn't quite as strong as you want it to be to file a complaint, or there might be other reasons why you don't want to. And I think there is a time and place for pre-suit demands. And if you have an open and shut case of bad conduct, perhaps certainly, just file the complaint might be the best advice. But if the client's hesitant for whatever reason to do so, one thing you can do is write a very detailed letter or explanation to the company who hired these individuals in this example. They may or may not know about the wrongdoing of the former employees that came over. And they might be quite upset about it and take action all on their own. That can't be counted on. And I'm a strong believer that if you do send a letter saying we will sue if this is not remedied, then you don't do it. That's a risk in and of itself, as I think we'll get to later. But there could be a time and place to notify the opposing company, the new employer, for example, about contractual obligations or about wrongdoing. And at the very minimum, if there's later lawsuits, they can't say they didn't know about it at that point.
I agree with Wolf. I think there is a lot of value. I agree with both Wolf and Michael in that to the extent you have evidence of wrongdoing, time is of the essence. I'm going to keep saying that the entire presentation. Time is of the essence. A trade secret owner has an affirmative duty to take reasonable steps to protect her trade secrets or risk potentially losing them, right? So you got to act fast. But in a circumstance where they're still gathering evidence or that maybe perhaps the wrongdoing hasn't stopped, sending a cease and desist letter to out serves a lot of useful purposes. What I usually do is I send in a letter and copy their employer. Why is that important? Because number one, and this is the most important one, it automatically informs them, hey, there is a threat of litigation, and you spell it out in the cease and desist letter. Preserve everything, right? That's very important because, as Michael and as Wolf said, there's this oftentimes potential defendants have this inclination to go and clean things up, and you want to make sure that you warn them. Because if you don't, they're going to say, I didn't know there was a threat of litigation, and you get into an argument whether that's true or not. But if you send them a cease and desist letter, that's absolutely going to be true. The second thing is if you identify the applicable agreements that the former employees are violating, you're also informing employers that they're tortiously interfering with your contractual obligations. So in addition to actually having a trade secret claim against a new employer, you're by informing them, you're opening them up to a tortious interference claim. So I think that's one of the very good points that Wolf brought up.
Okay, so we're now in the position where we're ready to file suit. We know Mike's preparing the complaint because that's how he jumps out of the gate. What considerations do you need to take into account as you're deciding to prepare your complaint and file it? Yasser, why don't you jump off with this one?
Sure, happy to do it. So, do you have the right? One of the things that I initially think about is, are there any agreements that preclude you from filing litigation? And what comes to mind are, there has seldomly, but it does happen, there's an agreement to mediate, right? Or there's an arbitration agreement. I'll focus on the arbitration agreement because that's the more important one in my mind. Just because there's an arbitration agreement doesn't necessarily mean that you're bound by it, right? I would identify whether it's enforceable by the applicable law. Sometimes an employee performs 90% of their work in another state that might have a different arbitration statute that invalidates the arbitration provision, and it still allows you to actually proceed with litigation. And even if there is an arbitration provision, do you have the right to seek injunctive relief in courts? So that's also very important, because sometimes if you initiate arbitration, the arbitration process is slower and may halt your ability or handcuff your ability to actually get as much of an immediate injunctive protection as if you proceeded in the court system. Another thing that I would consider is timing. Are you ready? Oftentimes the best way to identify when you're ready is identifying where to file. So in most instances, a plaintiff has the opportunity to identify the different courts where they could actually pursue litigation, right? Based on the jurisdictions, the governing provisions of the agreements, the venue where the wrongful conduct took place. So familiarize yourself with the laws applicable to those different areas and identify which areas are more favorable, right? So, for instance, some of the venue options might require identification by the plaintiff of a trade secret, and some don't. To the extent a plaintiff has not identified their trade secrets, it might be more favorable for them to actually pursue litigation in one state or another. Some states also allow the recovery of attorney's fees, like Texas, in the event that there's a breach of contract claim for violating confidentiality agreement. That might be more favorable, because even though the trade secret statutes generally allow for the recovery of legal fees and trade secret claims, sometimes statutes such as the one in Texas actually make it easier. There's a lower hurdle. And assess the type of court that you want to be in. In state court, in Texas, for instance, you can go straight and get an immediate hearing before the court for injunctive relief. In federal court, you subject yourself to motion practice. So if you file a trade secret claim and you're seeking immediate injunctive relief, and the defendants file a motion to dismiss, unfortunately, in federal court, which I'm a big fan of, sometimes the motion dismiss practice actually slows down a plaintiff's ability to move forward very quickly.
Yeah, I'll back off my aggressive stance a little bit. What Yasser said is all very important. And what I want to emphasize is there's some trade secret cases that are better off not filing. And I don't take filing a trade secret complaint lightly at all. I mean, it's something that you should do if you have the evidence to do it. But there are also times when you just don't have the evidence, right? And that's a time to look for a different path. And that different path could be a different type of cause of action. It could be, as Wolf mentioned before, a cease and desist letter, or trying to get to a resolution through negotiation, and filing when you're ready. And that's important too. There's it is urgent. It's almost always urgent, but there's some real reasons not to rush into court or rush into a trade secret complaint. So, I think my view on it is that when you have the evidence, you'd be aggressive about it. When you don't have the evidence, look for another path to achieve your objectives.
The only thing I'll add is that, as far as where to file, you've got a federal statute, of course, the Defend Trade Secrets Act. You could sue using that in any federal court. And almost every state, I think with the notable exceptions of New York, probably has adopted the, some version of the Uniform Trade Secret Act. So there's a little bit more uniformity on these kind of lawsuits than there was probably 20 years ago.
Thanks, Wolf. So now if you've made the decision to pursue litigation, as we all know, litigation is never without risks. What are the risks you would share with a client as you pursue trade secret litigation? What do they need to be worried about? Wolf,
yeah, I think Mike was already hinting at this. So, you're under a duty to protect trade secrets, and sometimes that means litigating. However, if you lose, and there's multiple ways you could lose a trade secret case, a court or a jury could find that you didn't take reasonable steps to defend the trade secret. Reasonable security measures weren't in place. You could lose because there's a finding that it's not actually confidential. It's something that's known. Once you have that out in the world, such a finding, that could actually hamper your ability to protect that trade secret in the future. So that's why it's important that you be judicious in these kind of causes of action. And keep in mind, again, that there's sometimes alternative causes of action that don't carry that exact same risk. As in any lawsuit, something we'd always warn a client about is cost. You can't not include that in here. These kinds of cases are rarely cases where you can file a complaint and then let the case coast for months and months. There's often temporary restraining orders. There's often expedited discovery. There's often expedited trials. All of that is very expensive, which is why that's something that has to be discussed up front and made very clear. As a plaintiff, you also have to be aware that there are potential counterclaims that could be brought against you. The DTSA, for example, allows a successful defendant to obtain its own attorney's fees if a claim has been brought in bad faith. Now, that's quite a high standard, the way the case law has been interpreting it. But you have to be aware of the possibility, especially if you're in sort of more of a middle ground type of situation. Lastly, oftentimes with our hypothetical former employees, you might have restrictive covenants or non-competes or non-solicitations, and that's kind of outside the scope of this presentation, but you might have a form that's been used with hundreds of employees, something like that, and a court might decide that it's too broad and somehow, and that's something else you have to just bear in mind.
Thanks. Mike, Yasser, other things to add about risks that you've seen?
I would just emphasize what Wolf said, the cost and control, two things that I think are very important it's very important to discuss with a client at the onset of the matter, so they're not unduly surprised later. Nowadays, discovery, we're in the technology age, and we've been in the technology age for a long time. It's only gotten worse. We're wearing all sorts of wearables now, rings and watches, and I could go on and on. And every one of those devices accumulates data, and that data is evidence. And they have geolocation, and they can tell you where everybody's been. So if you want to find out and reverse engineer whether an employee that while they were employed by your company was at a competitor's, you want that information, right? Because that's evidence. Because of that, it gets so costly. It gets so costly and so quickly. We're getting to the point where the forensic costs are now rivaling the legal costs. It's that expensive. You're talking terabytes of information, and some courts are reasonable about trying to temper the cost, but others don't because it is evidence, right? So at some point, it really impacts both in the plaintiff and the defendant alike, and it could potentially impact their decision-making as to where they go with the case. The other thing that I think that is very important to discuss at the onset is control. Some plaintiffs think, oh, we'll file this lawsuit, we'll see how it goes. Maybe at some point things don't go our way, we dismiss it. Well, the minute that the other side files a counterclaim, even if it's a counterclaim, some bogus counterclaim, right, frivolous action, the minute that happens, the plaintiff loses control of getting rid of the case if they get tired of it. Because if they do, that counterclaim remains. So that's another important issue to discuss at the onset with clients because it's a risk.
Yeah. Okay. And I would also say, you lose control in the discovery process too, right? And we've get clients who file a trade secret claim and they get a request from the other side for all of the documents that they claim are trade secrets. And the client says to us, well, I don't want to turn those over. Those are mine. Those are my secrets, right? Once you enter into this process, there are no more secrets. There's things that can be done to make sure that whatever you disclose in discovery remains confidential. But the other side is certainly entitled to anything that you claim to be a trade secret. And that's, sometimes a business risk for a client. A client may feel that they'd rather not disclose those things to a competitor, even if there's protective orders or whatnot in place. And you don't know where that discovery is going to lead. You don't know who might need to give a deposition, and so forth and so on. So that's, to me, is another risk of the process, is just subjecting yourself to the other side's discovery.
Right. We're going to talk about discovery shortly, but before we do, I want to touch on the content of the complaint. Your client's given you a green light to file a complaint, but what do you put in it? Who are you naming, and what are the causes of action that you're going to assert? Mike?
Sure. So I guess, first of all, I'm a big advocate of detailed pleading. In other words, not saying we have a trade secret and you've stolen it, but what are the trade secrets? What are they? Why are they important? How do they give the other side a competitive advantage? It's to me very important, for a few reasons. One, it gives your complaint credibility for the other side. It's not, oh, well, a competitor filed a lawsuit against us for trade secrets, but we don't know what the trade secrets are. This is a serious allegation, and we need to investigate this and find out what happened. And it gives you credibility to the court. And I think that makes a difference when you're trying to get discovery, not to get too far into that phase of things. But I do think the judges and clerks look at the complaint and take a complaint that's detailed much more seriously. The other thing I never want to do, and Yasser touched on this before, is file something that opens my client up to a motion to dismiss. And that could be just, vague pleading. It could be trying to sue somebody in a venue that's favorable to you, but is a venue where they can claim they don't have any business operations, so a jurisdictional type of argument, forum nonconvenience argument. Anything that's going to slow it down through the pleading process, I really try to avoid, because you want these things to move and move forward quickly and not be bogged down in motions. And then, the other thing I'd say is consider other claims. We've talked about this a little bit, but there's almost always other claims you can bring that don't have the high bar of a trade secrets claim. A simple non-disclosure agreement, if the employee that took information, signed an NDA or signed a confidentiality covenant, those are very valuable, and it gives you kind of a lower standard for protection of your information. The other thing to keep in mind, I always like these claims, is that every employee in just about every state that I'm aware of has a duty of loyalty during their employment to their employer. And my view, at least, is that an employee who's going on their employers' information systems at 3 a.m. to find documents that they can download and maybe use at their next job that they've accepted, but they haven't told their employer they've accepted it, is violating that duty of loyalty. And so I always like duty of loyalty claims because they're just a lot cleaner. You don't really need to establish that this piece of information is necessarily a trade secret or even necessarily confidential if the purpose of the employee accessing it is to help a competitor. So just a lot of things to keep in mind, but think about what else you can plead as an alternative.
Yeah, I want to pose a particular question to Yasser and Wolf. So, your former employee steals trade secrets and goes to your competitor company. The client calls and says, sue everyone, including the new employer. How and what considerations do you take into effect in deciding whether you want to only name the employee or the employee and the new employer, and are there advantages to one or the other?
The first thing I would look at is what evidence do you have against the employer in that circumstance? So it sounds like you have some evidence that the employee did something improper when they left. Now they're working for your competitor, let's say, or your vendor, or perhaps even a customer. What do you do against that new employer? I mean, if they suddenly have a competing product or they've been able to replicate things, again, like I was speaking on earlier, overnight, the employee gets there and all of a sudden they have everybody's information. They have exactly the right price to offer folks, or they have some new product on the market. I think that's enough for me to say include them.
One of the things I like to do as well, I couldn't agree more with Wolf in that gathering information about the employer is important. I think it's true about the former employees as well, but you'll note that, or one of the things that I've noticed over my career is that each company that's engaging in that type of wrongdoing tends to have a reputation, right? Some of them are worse than others. I remember one particular case we had where a company was essentially became from a non-existent company to an international company, doing the same thing over and over again. They seemingly made a financial determination of the costs associated with going and taking business units in such a fashion, and they decided that it can be profitable, right? So if you're dealing with that type of a company, then that might give you an inclination to be more aggressive. If you're dealing with a company that's never been sued before for that type of thing, then it may give you pause for concern and prompt you to gain additional information. I think ultimately what it comes down to is doing your homework and making sure you have the requisite information so you can make an informed decision.
Okay. And there might be cases where getting an injunction, for example, against the employee is enough to stop the harm, at least at the beginning, until you can find out more. If you don't have that evidence of the employer's use yet, or use being generally a part of misappropriation, but the employee is restrained from using the information, including in his employment, first of all, that's going to involve his employer, even if they're not named in the complaint. They're going to have to be involved, and they're going to have to be aware of it, and they're going to have to be on their toes.
Right. So we've talked a lot about discovery. We've heard the term expedited discovery put out there quite a bit. How do you decide in these cases whether you want to pursue expedited or normal discovery? What are the considerations you discuss with clients? Yasser?
That is a very important question because it can be quite onerous. When you're talking about expedited discovery, let's take a situation where you have the crown jewels of how to make a widget that gets out to a competitor. You want to act quickly, but you got to identify what type of discovery is going to be sought in that expedited discovery process. Usually expedited discovery is initiated for purposes of getting to the temporary injunction point so that you can ask the court to issue an injunction that prohibits the other side, the defendants, from using that formula or secret, right, pending the trial on the merits. So it's supposed to protect the plaintiff and the plaintiff's trade secret throughout the litigation, which can sometimes take a very long time. Well, how many depositions are at issue? Are there patents? How many patents? Where are the, if you're going to have corporate representative depositions, what are the topics and how many different people are going to be needed to actually serve as a corporate representative, right? You really want to think about the scope of what will be entailed in that process, because if it's a lot, and be careful what you wish for is what judges usually say, right? If it's a lot and the judge gives you 3 months to do everything, it may not be possible. And if you're the plaintiff and you need that expedited discovery to get that preliminary injunction, then at the end of a chance, you may not have the requisite evidence to win at the preliminary injunction. So I think having that initial conversation with your client is so incredibly important. I'll give another example. Not too long ago, there was a case that was initiated. The plaintiff went in. They asked the court that they wanted expedited discovery and they wanted a preliminary injunction. It's in federal court. And pending, so they could have a injunctive relief pending the trial on the merits. And the federal judge said, I'm going to invoke my discretion to combine the preliminary injunction and the trial. You will be going to trial in 90 days. And that really caught the plaintiff, well, and defense counsel by surprise. So in that type of a situation, you really have to take into consideration the possibility that you're going to go at a very quick pace, and you've got to evaluate your ability to do so.
Mike, Wolf, anything to add on that?
Yeah, I mean, I really, for that reason, often discourage clients from filing for injunctive relief in these situations. And, I think in addition to the cost and the possibility of, a very expedited process, you have the risk of losing. And even though it's preliminary and even though it doesn't mean that you lose the injunction, you lose the case, I think it just takes away a lot of momentum if you go for expedited discovery and try to get an injunction and fail, right? The other side then thinks, well, this is over. The judge has already decided, right? And so I think up front it's good to be aggressive, but at this phase, I think sometimes a low and slow type of approach, can be preferable as long as you feel like you've stopped the bleeding. In other words, there's sort of ongoing misappropriation of information. But there's not always an advantage, I don't think, in being too aggressive in pushing discovery forward on timing. And Wolf, what are your thoughts?
Yeah, I agree entirely. I mean, expedited discovery is a gamut. It's tough, and sometimes it's necessary, but you want to assess whether it is in your case or not. Something else just on discovery you have to mention in trade secret cases is the importance of a properly tailored protective order in the case. Your trade secret is not going to do any good if it's publicly disclosed in your effort to protect it. So that's something that can be quite cumbersome sometimes, but it is necessary as well.
So that's a critical point you make, Wolf. So you're suing about your trade secrets, and now you're telling the court what you want in terms of relief. Okay, what kind of damages are recoverable? What damages are you seeking, and are there specific models you're using to try to quantify those damages? Thoughts, Wolf?
Yeah, so we've already touched on one of the reasons you would sue, which is injunctive relief. A court order saying, hey, bad guys, stop doing X, Y, Z, stop using these trade secrets, purge yourself of that information. But of course, you can also seek monetary damages, or I should say, in addition, you can seek monetary damages, which is why a lot of trade secret cases have been filed and they've been getting more popular. If you just Google trade secret judgments and awards, you'll see, State Court in Virginia, $2.4 billion with a B, Eastern District of Virginia, $920 million, and the list goes on and on. So large awards are being done. If you're a successful plaintiff on a trade secret claim, you're entitled to compensatory damages, lost profits. You could claim unjust enrichment, the benefit that the opposing party obtained through their wrongful acts. If you're successful under the DTSA, for example, you can get double compensatory damages as exemplary damages, which is how some of these numbers are getting. And to get those, you have to show that the action was willful and malicious. But if somebody is stealing trade secrets and you prevailed on that claim, you've got a very good chance of meeting that burden as well. Something else that makes trade secret claims somewhat unique is you might be entitled to seek as an alternative means of damages what's quote a reasonable royalty. And if there's any patent litigators on here, of which I'm not one, that's going to be a concept familiar to them. But, it's sort of an alternate means of damage where maybe you can't actually show how much money you lost as a result of the bad acts that you need to be compensated for. You could try to seek this measure of damages, which is more about if you had an imaginary arm's length transaction where party A was selling this information to party B, how much would they be willing to pay for it? And, as with the other forms of damages, that's something that, might require expert testimony to establish, but gives you a lot of flexibility. I think one quite old Fifth Circuit case said that you can be imaginative in how you calculate this royalty, which as a plaintiff's lawyer is going to be attractive to you when you're coming up with your damage model. Mike or Yasser, any thoughts
Sure.
on damages?
One of the things that I've always found interesting is the fact that and I'm going to use Mike's phrase because I think it's so on point. Mike said that the overarching goal is to stop the bleeding, and that's what trade secret cases are all about. It's protecting your trade secrets, which often means stopping the bleeding. In the factual scenario that we're using, for instance, preventing our former employees from continuing to steal our business operations, our clients, right? When you file a lawsuit, you do stop the bleeding. And what I find somewhat interesting is that the fact that if it's done right, if you stop the bleeding correctly, it actually decreases sometimes the potential amount of damages that the plaintiff's going to have, because it precludes them from continuing to solicit your customers or use your information in unfairly soliciting your customers. So sometimes there's an inverse correlation between how successful a plaintiff is in using the judicial process to protect itself against unlawful competitive practices and the amount of damages that will be available at the end of a jury or bench trial.
Mike, any other thoughts to add?
Yeah, just that once again, Yasser's right. That is the goal. And I although there are big, verdicts sometimes in trade secret cases, I never file a trade secrets case with the goal that we're going to obtain a 9-figure verdict or what have you. The goal, as Yasser said, is get the conduct to stop, have a chilling effect on the other side, get them to be a lot more cautious about what they're doing, and then you can kind of talk about damages. And there are big numbers out there. There's no question that there's been juries that in certain cases have awarded a lot of money. But you do have to keep in mind, your damages are often intangible, right? You have a document, a file, a piece of information, and how do you put a value on that? And it can be done. It is done. But it's not always intuitive how that's going to happen. And, one of the uphill challenges always in a trade secrets case is, okay, you've proven that the other side has the document. How do you prove that they've used it and how they've used it? And that's, I think, always a little bit of a barrier to proof of damages. So, on the one hand, you can have a big payday at the end of one of these cases. On the other hand, it's not always about money. More often, it's about business goals and objectives.
Okay, with that, let's turn to our last topic: trial versus settlement. Like most litigation, the overwhelming majority of trade secret cases actually settle and don't go to trial. And so we want to talk about, what are your views? When might one be better than the other? And if you were settling, are there any types of terms that you think you would want in there that would be non-negotiable? Any new creative terms you're seeing more frequently? Mike, what are your thoughts here?
Yeah, so just picking up on my theme, I think that there are some good creative settlements. I think that you should always be thinking about these cases in terms of what are your business goals coming out of this. I mean, there's some things that, are probably in every agreement. We always would say that the employee that took information has to represent a warrant that it's been destroyed or that it hasn't been used. But, I always encourage clients to think about, what can you do? What can we get out of this that's going to have some value to the business? So, for example, are there clients that you're really concerned about this competitor getting into and using your trade secret information to get into? And can we keep the personnel that left that might have relationships with those clients away from the clients for some period of time? Likewise, if you have an employee that's gone over to a competitor in a similar role and has taken information that might be valuable in that role, can you get the other side to put that person, out to pasture, so to speak, for a while? In other words, move them, into a different geography, move them into a different role where they're not going to be as much of a competitive threat. And you need to obviously be mindful that you're not making anti-competitive agreements that get you into more trouble. But when you have somebody who's taken documents, it does give you leverage to these kind of remedies that sort of level the competitive playing field. So those are things I always like to look for, those opportunities in a settlement in addition to money. Sometimes those kind of things can be better than money in some ways.
So I couldn't agree more with what Mike said. The one thing I'll add is that in formulating these settlement agreements, it's important to remember the reason why the trade secret owner initiated a lawsuit to begin with. Each trade secret owner, again, I've said this before, and I promised you guys that I was going to keep repeating it, so I'm going to make sure I'm not lying to you, is that you have an affirmative obligation to protect your trade secret. What does that mean? You have to take reasonable steps to ensure that anybody that's in possession of them gets rid of them. That means oftentimes trade secret owners, even if they don't want to, they have to initiate a lawsuit or risk waiving their right to a trade secret and the protections afforded to trade secrets. For that reason, when you're formulating a settlement agreement, it's very, very important to include in it a request that the defendants purge any information that's at issue in the case from their servers, from their personal computers, from their work computers. So important, because sometimes you go through and negotiate this process without actually negotiating what we call a purge protocol. And then you finalize the agreement. Sometimes it's in a mediation, and everybody thinks, oh, well, everybody's going to agree to that later. So it's implicit in the mediation agreement that that's going to take place. And when you go back, the lawyers go back to their respective offices and they try to draft it, and lo and behold, the plaintiff's lawyer actually includes that provision. The other side's going to object because it can be pretty onerous. It's not easy purging information from that's at issue in the dispute from every potential repository where it may be present. So that's something that I would consider a non-negotiable term.
So we've gotten a few questions come in, and we've only got 5 minutes left, so we're probably not going to be able to get to all of them. But I did want to throw out a couple questions to the group. Whoever wants to take this can, but we were talking about pre-suit cease and desist letters. And Mike, perhaps whether, what kind of considerations need to go into those. And we had a question that specifically asked if you need to worry about disparagement or similar type claims when you're sending such a letter.
Yeah, and I think the answer is you do. But, a couple things to keep in mind. One is, truth is always the best defense to a disparagement claim, right? And it kind of goes to what we talked about before, which is, you need to make sure you aim before you fire and make sure you have evidence to back up what you're saying in a cease and desist letter, and don't do it just as a way to try to intimidate somebody or rattle someone's cage, and then bring their employer into it. But the other way to deal with it is, how do you word the letter, right? In other words, if you come out of the gate saying that, that this employee, has blatantly stolen millions of dollars in valuable trade secrets, right? That might get you in trouble, right? Be factual as to what you have, right? What the employee did, and what you can prove at that stage of the case. And don't sort of characterize it. Just try to be direct and factual about what you think happened. And you can even kind of frame it as, it's our client's belief, right, that this occurred, which is a much easier statement to back up than you're a thief, right? So that's, those are things to keep in mind. I mean, it's never really a deterrent, I don't think, to us in trying to address a misappropriation issue. But you need to just sort of stick to what you think you can prove. And if you stick to that, you should be fine.
I couldn't agree more with Michael. I think the one thing I would add is you're insulated a little bit more in sending those communications if they come through a lawyer. Oftentimes, companies are tempted to, when they find out, I mean, I can just envision it. I would be infuriated, right? And the temptation is just to draft an email and just hit send, right? And in doing so, you might not have the benefit of viewing it and analyzing it from a legal perspective. So I would always advise to either preferably hire outside counsel, or alternatively, go to your in-house legal department and make sure that you get advice before firing off such a message.
And we might have time for just one or two words on this question, but what trends are you seeing with respect to non-compete litigation, which is obviously often tied up with trade secrets?
Sabrina, you want to take this away as our resident expert?
Being in California, the concept of a non-compete is virtually non-existent. And so it's, we're seeing a trend also at the federal level to kind of parallel itself on California. Look, there's a desire to have free employee mobility. And so I think what we're seeing is employers are going to have to rely more and more on the other things. They're not going to be able to rely on some written agreement not to go compete and not to work in the same industry. If we all were not here, we would be lawyers somewhere else. So we can kind of understand the notion that having non-competes is problematic conceptually for some people. I think you need to rely on duty of loyalty. You need to rely on people not to misuse your trade secrets, and don't count on being able to just preclude people from working in other enterprises unless it's in conjunction with the sale of a business and you can fit one of the limited statutory exceptions.
Yeah. And speaking of that, outside of California, I think it's kind of the same scenario. The legislatures and courts are increasingly hostile to non-competition. So, you're not preventing somebody from competing. What you're trying to do is protect your clients, protect your information, protect things that you as an employer have invested in and have equity in, not just try to keep somebody out of the business. That's the way I would look at it.
So I do want to temper the message, though, because I am in the great state of Texas, and I know there's a lot there's a lot of states that emulate Texas's position, which is non-competes are enforceable. And I do agree that there is the federal government is looking at or assessing the non-compete state of things, but they are enforceable. And one of the things I would, in Texas and many other states, and one of the things I would recommend to trade secret owners that you couple your trade secret protection with non-competes to the extent that you can. Now, obviously, you always want to take incredible care to make sure that the provisions are reasonable so that they're not held unenforceable later or reformed. But while the state of non-compete law is in flux, if you will, that to the extent that you have that protection available to you, that you certainly take them up on it.
Yeah, no, I think the only thing I'd add, and I think what you just take away from all this is that there's no one size fits all. We can't tell you you can use one agreement in all 50 states. And there's a reason we're not, we want to help you protect as best you can for each jurisdiction that you're in. All right, with that, we're slightly over time. So I'd like to thank everyone who stayed and joined us today and has made it to the end. We hope you found this session informative. And if you have any follow-up questions, don't hesitate to reach out to any of us or to your McGuireWoods contact. The third installment of this webinar series on trade secrets is going to take place on November 30th at 10 Pacific, noon Central, 1 p.m. Eastern Time. You can register today if you want to by going to the resources link that's within this platform, or you can go to our firm's website, or you can reach out to any of us directly, and we'd be happy to help you get registered to attend. And we look forward to you joining us then. Thank you.